Good morning. Can everyone hear me?
Yes, ma'am, we can.
So it looks like we're just waiting on one juror. So I figure we can take this time for the jurors that we already have to see if there are any conflicts. So if the advocates can turn their video on so we can have the jurors get a look at you. Ms. Kaplan, do you see anyone you recognize? Okay. And then do we have Mr. Kaplan too?
Yes.
Do you see anyone that you recognize?
No.
Okay, thank you. Okay, and it looks like we're still just waiting on one, so everyone hang tight. Good morning. Can you hear me? Hi. If the advocates can turn on their video to see if there's any conflicts. Ms. Mathias, do you recognize anyone? Okay, perfect. Okay, so it looks like we have everyone here. We're just waiting for the all clear, okay?
Excuse me, my alarm in my apartment is going off, so I'm gonna need a brief moment to figure out what is happening.
Okay, no problem.
Thank
Thank
you.
you for letting me know. I appreciate it. Okay, so I think we have everyone now. It's just a matter of waiting for the alarm situation to get fixed. So just let me know when that's taken care of, someone on her team. Okay,
Yes, Your Honor. Be sure to let you know as soon as it's dealt with.
perfect. And it's no problem.
I'm so sorry about that. It's been dealt with.
Okay, it's no problem at all. Okay, so I think we have everyone, so we're good to get started. We just received the go-ahead. So calling the case of the state of West Carolina versus Timothy Ray. My name is Judge Phillips. Scoring judges, I think you've already done this, but please look to the lower left of your screen and turn off both your audio and video. They should remain off until the end of the trial. You should also have your video set to hide all non-video participants. Again, it looks like this has kind of already been done. So we can only see the advocates and myself. So at this time, let's start with appearances from the people.
Good morning, Your Honor. My name is Alex Messmore, alongside my co-counsel, Ms. Elizabeth Wireman. We represent the state of West Carolina in today's proceedings. For the court's notice, we are team number 102. We have copies of our notices of appearance. Would Your Honor like us to drop a copy in the chat?
Sure, go ahead.
Yes, Your Honor. Before we begin, the state has a few housekeeping matters to address, as well as a motion in limine when Your Honor is ready.
Okay, let's hear from the defense first, introductions.
Good morning, Your Honor. My name is Malcolm Mills, here on the behalf of the defendant, Timothy Ray.
Good morning, Your Honor. My name is Danielle Rivera, also here on behalf of the defendant. And when Your Honor is ready, we also have some housekeeping and one motion in limine.
Okay, thank you. So let's start with the motions in limine and then we'll get to housekeeping. So we'll hear from the prosecution first.
Yes, Your Honor. At this time, the state moves in limine to exclude any evidence or testimony of the defendant's mother's alleged mental illness. Your Honor, this evidence or testimony is not based on reliable facts or data as is required under Rule 702, and its prejudicial value far outweighs its probative under Rule 703 of the Federal Rules of Evidence. Your Honor, just a little background. In today's case, the defendant is claiming to have not appreciated his actions on October 17th, 2018, when he strangled his son to death. He is claiming that he has schizophrenia. The defense has an alleged expert, Dr. Riley, who bases his opinion and testimony and diagnosis of the defendant partially on this evidence or testimony about the defendant's mother's alleged mental illness. But all Dr. Riley knows about the defendant's mother's alleged mental illness is what the defendant's father, Abe Ray, told Dr. Riley. Abe Ray told Dr. Riley that the defendant's mother suffered from mood swings and was eventually institutionalized. But by the time the defendant's mother was institutionalized, Abe Ray was already estranged from the defendant's mother. Dr. Riley has had no peers from the institution back up this, and he has not seen the defendant's mother's medical records, Your Honor. And we understand that expert witnesses may rely on inadmissible hearsay to form their opinion, but any evidence or testimony about the defendant's mother's alleged mental illness should not be heard in today's case because it was not based on reliable facts or data under Rule 702, and its prejudicial value far outweighs its probative under Rule 703.
Defense, do you have a response?
Yes, Your Honor. Both the prosecution's expert and Dr. Riley agree that genetics and family history of mental illness have a big part or huge impact on a person's mental health development. And Mr. Ray's schizophrenia diagnosis was in part based on his mother's mental illness, as well as the fact that she was institutionalized. The prosecution's argument goes to the weight of the evidence, not the admissibility, and they're certainly welcome to cross Dr. Riley on that fact.
Prosecution, do you have anything you want to add to that?
Yes, Your Honor. Again, this evidence or testimony was not based on reliable facts or data. This is not a weight issue, Your Honor, because there is no proof, reliable proof or facts that backs that the defendant's mother had a mental illness. So therefore, their witness saying that the defendant's alleged mental illness is somehow linked to the mother's alleged mental illness has no bearing or weight in this case at all.
Is it true that your expert also says that genetics are a way to diagnose a patient, or that genetics are used in a case like this?
Your Honor, it is relied upon, or I guess the medical field does have this theory that it could be relied upon, saying that a child might have linked mental illness to a parent. But Your Honor, you are the gatekeeper in today's case, which means you decide if you believe that this evidence or testimony could be relied upon, which in today's case, it should not be relied upon because it was not based on reliable facts or data.
Okay, I'm going to allow it. You can explore some of the points you made on cross-examination.
Yes, Your Honor, that is the only motion in limine the state has today, and we are ready to proceed with housekeeping when Your Honor is ready.
Okay, so let's hear the defense counsel's motion in limine.
Yes, Your Honor. Just to begin, the parties have stipulated that Dr. Mac LaGreca, the prosecution's expert, will not opine on whether Mr. Ray understood the wrongfulness of his actions at the time he killed his son.
Okay, thank you.
And our first motion is to exclude Dr. LaGreca's testimony that 1 in 5 people being psychologically evaluated in the context of a criminal case are malingering. This information comes from preliminary research conducted by Dr. LaGreca for an upcoming article that he's writing. This information has not been peer reviewed, and there is no information about sample size or the manner in which this information was even gathered. Additionally, these statistics will invite the jury to look at the statistical probability of malingering instead of focusing on the specifics of Mr. Ray's case. As such, we move to exclude this evidence under Federal Rule of Evidence 403.
Do the people have a response?
Yes, Your Honor. The state only intends to go into the statistics surrounding the odds of malingering. And Your Honor, just for some background, Dr. LaGreca will testify that 19% of people facing criminal charges, like the one the defendant here is facing today, do in fact malinger. The study that opposing counsel wishes to exclude is not going to be admitted in today's trial. Simply the fact that studies relied upon by our expert today show that 19% of people facing criminal charges do in fact malinger. This preliminary research will not be explored in today's proceedings, Your Honor.
Defense, do you want to be heard further?
Yes, Your Honor. I'm not specifically talking about the preliminary research. My argument is that the statistics have no bearing. We don't know the sample size, and it's unduly prejudicial to allow the jury to hear this evidence.
Does the prosecution have a response to that? It sounds like she wants you not to talk about the 19% at all.
Yes, Your Honor. Pursuant to Rule 703, experts are allowed to disclose even inadmissible hearsay if they relied upon it in forming their opinion. The defense put the defendant's mental state at issue in today's trial, and Dr. LaGreca relied upon the statistics shown throughout his field of forensic psychiatry in reaching his opinion today. Your Honor, Dr. LaGreca certainly qualified as a forensic psychiatrist and relied upon studies that show that 19% of people facing criminal charges do malinger, and forming his opinion today that that the defendant is malingering. Your Honor, this evidence is due to be admitted as this expert relied upon it in forming his opinion under Rule 703 of the Federal Rules of Evidence.
Okay, so since the expert relied upon it, I am going to allow it. Defense counsel, you can obviously raise your points again in cross-examination to lack of sample size and things that you've expressed are a concern in motions in limine. But I'm going to overrule the motion and allow the testimony to come in. Are there any further motions on behalf of the defense?
No, Your Honor. With that, we only have housekeeping.
Okay, so let's start with the housekeeping from the prosecution.
Yes, Your Honor. May we assume that all witnesses are pre-sworn?
Yes.
Your Honor, today we would like to invoke the rule under Federal Rule of Evidence 615, sequestering all witnesses that are not parties or experts. Specifically, the state wishes to not exclude Dr. McLaGreca from today's proceedings.
Any objection from the defense?
Your Honor, we only ask as long as Dr. Riley is also permitted to stay within the courtroom for the proceedings, then we don't object.
Okay, is the prosecution okay with that?
Yes, Your Honor.
Okay, anything else?
Yes, and Your Honor, in order for the scoring judges to hear our evidentiary objections, may we assume that all sidebars and evidentiary arguments are outside of the presence of the jury?
Actually, I would like you to ask to approach or be heard at sidebar, and then the sidebar conversation will be constructively at sidebar. So ask, and then we'll have it in front of the jury, obviously.
Yes, Your Honor. There are some stipulations in today's case. May we read them as they become relevant?
Yes.
And Your Honor, in today's case, the state intends to offer an expert, Dr. McLaGreca, in the field of forensic psychiatry. When laying the proper foundation, would Your Honor prefer us to simply lay the foundation and move on, or formally tender?
Formally tender, please.
Yes, Your Honor. When seeking to publish exhibits in today's trial, would Your Honor prefer us to simply ask the first time or each subsequent time as well?
Ask each time.
Yes, Your Honor. We have spoken to opposing counsel prior to trial and have stipulated to the admissibility of Exhibit 4, which is located on page 45 of the electronic notebook. That is the Miranda waiver signed by the defendant. We've also stipulated to Exhibits 6 and 7, which are located on page 53 and 54 of the record. Exhibit 10, which is a search history located on page 57. Exhibit 17A, which is located on page 93 of the record, and that is the DSM entry for schizophrenia, as well as Exhibits 21 and 23, located respectively on page 98 and page 100, as well as Exhibit 27, which is located on page 104 of the electronic notebook. The state wishes to introduce these into evidence at this time, Your Honor.
And assuming no objection from defense, as you stipulated to the admissibility of those?
That's correct, Your Honor. We have no objection.
Okay, they're admitted. Thank
And
you.
Your Honor, yes, Your Honor. Pursuant to local rule, when seeking to admit evidence, we will be directing court and counsel to the exhibit number as well as the page number in the electronic notebook.
Okay,
And that is all the housekeeping matters on behalf of the state. We are ready to proceed with opening statements when Your Honor is ready.
thank you. Are there any more housekeeping matters from the defense?
Yes, Your Honor. We ask if we may be permitted to remain seated for our objections so that we may stay within our camera frames.
Sure, whatever you're comfortable with is fine with me.
And then, Your Honor, the record contains a number of exhibits which have been pre-marked for identification. And we ask that the exhibits retain their original numbers and therefore may come into evidence out of order.
Okay, I mean, that's fine, assuming that's fine with the prosecution.
It is, Your Honor.
Okay,
And with that, Your Honor, we have no more housekeeping matters. The defense is ready for trial.
okay, sounds good. Thank you. Okay, so it's now time to hear opening statements from each party. Everyone should make sure they're in speaker view at this point, and that's the button in the top right of your screen. And attorneys, make sure you mute yourself, your audio and video, so that we can pay attention to the attorney who's speaking, okay? All right, so we'll start with opening statements from the people.
May I proceed, Your Honor?
Yes, you may.
Nathan Ray was a 6-year-old little boy. A 6-year-old little boy with years of soccer games and birthday parties ahead of him. A 6-year-old little boy with a future. On October 15th, 2018, his mother, Jessica Ray, hugged him before dropping him off at kindergarten, knowing that he would spend the next 2 days with his father, the defendant. So Jessica hugged Nathan goodbye, completely unaware that this would be the last time she would ever see her baby alive. Because just 2 days later, Jessica Ray's worst nightmare became a reality. She drove to Nathan's school to pick him up, but when she got there, Nathan was not there. She tries to call the defendant, but he does not answer. She drives to the defendant's house, but no one is home. The car, gone. Jessica continues to worry until she learns the truth. The truth that you will learn today, that her baby, her only child, her 6-year-old son had been strangled to death and tossed into a shallow grave by her own husband, Nathan Ray's own father, the defendant. On October 17th, Nathan was sitting at his dad's kitchen counter. He was eating breakfast, drinking juice, but as 6-year-olds often do, Nathan accidentally spills his juice. With juice leaking all over the kitchen counter and the defendant's laptop, the defendant begins to scream. He orders Nathan into his bedroom, orders him to do jumping jacks, orders him to do high knees. Nathan does his best, but his little body just cannot keep going. He starts to cry. But this does not matter to the defendant. He yells at Nathan, "Keep going, do not stop." Nathan looks up at his dad. He begs for forgiveness. At this point, his body aches, his 6-year-old mind unable to understand why his dad is so angry. For a moment, everything stops. Nathan peers out of his bedroom door as he watches the defendant walk out. And he thinks, he hopes, he prays that this means the punishment is over. The defendant walks out of Nathan's bedroom into his own. He sits down on his bed and he pauses before grabbing his belt. He walks back into Nathan's bedroom, and this is when the punishment begins again. This time, the defendant beats Nathan over and over and over again with that belt. Nathan cries out for his mom, but this just makes the defendant angrier. He takes his belt, he wraps it around little Nathan's neck, and he pulls it tight. Minutes pass. Nathan loses consciousness, but the defendant does not stop, squeezing the belt tighter and tighter, watching as the life leaves his little son's body. With Nathan's lifeless body laying there, the defendant begins to calculate. He grabs his phone, Googles, searching for ways to get rid of a body, searching will bleach destroy a body, and searching for countries that do not extradite for murder. He is in control now. He grabs bleach, a shovel, and some trash bags. He wraps Nathan's lifeless body in a trash bag and tosses it into the back of his car. Then he begins to drive. He drives to Brandywine State Park, where he starts to digging his own son's grave, burying any proof of what he had just done, just as Google told him to. But the defendant's plan does not go off perfectly. He is later stopped at a DUI traffic checkpoint and brought into police questioning. And this is when he admits, he confesses to murdering his own son. Because of this, we have charged the defendant with first-degree murder. As the state, as the party bringing this charge, we have the burden, the duty to prove to you today, beyond a reasonable doubt, the defendant not only murdered his son, but did so with what is called malice aforethought. You see, it is undisputed that the defendant brutally murdered little Nathan. So all we have to prove to you today is that on October 17th, 2018, the defendant knew exactly what he was doing when he took Jessica Ray's son away from her. To help us prove this to you today, you will meet two witnesses. Today, you will meet Detective Booth, the lead detective on Nathan's case. He will tell you that he did everything he could to make sure that the defendant understood his rights and understood what was going on. Then he started to ask the defendant questions. And this is when he learned about the final moments of Nathan's life. This is when he learned exactly how the defendant murdered his 6-year-old son. And this is where he learned where to find Nathan's buried body. Prior to today, the defendant has brought an insanity defense. All this means is that he is claiming that he could not appreciate his actions on October 17th, that he could not understand that what he was doing was wrong. He is claiming that he has schizophrenia. Because of this, you'll meet Dr. LaGreca, an expert in forensic psychiatry. He will tell you that the defendant, he never claimed symptoms of schizophrenia until September of 2019, nearly a year after having been in jail for killing his son. Dr. LaGreca will tell you that the defendant was not suffering from a mental illness when he strangled the life out of Nathan, but instead, he is malingering, a fancy word that means that he is faking his symptoms to try to get out of trouble or to create a legal defense. Dr. LaGreca will tell you that the defendant was never suffering from a mental illness. No, today you will learn that he was calculated. He was controlled. And today he is committed to getting away with murdering his son. Which is why at the end of today's trial, my co-counsel Alex Messmore will come before you. And we will ask you to deliver the only verdict that the evidence supports and that justice demands. Find the defendant guilty. Thank you, Your Honor.
Thank you. Is the defense prepared to give an opening statement at this time, or do they wish to reserve?
Yes, Your Honor, we are ready.
Okay, whenever you're ready, go ahead.
Members of the jury, there's no way to remove the shock, the pain, and the disbelief we all feel about Nathan Ray's death. But it's not enough for us to look at how it happened. We must also look at why. And that's complicated. Timothy Ray isn't here to dispute that he killed Nathan, that he drove around with his son's body for days in his car trying to decide what to do, or that he buried his son in a grave in the park. But the answer to that other question, the why behind the what, well, he was following the voices he's heard for years, troubling him with delusions that his wife and son were plotting and scheming against him, tormenting him with hallucinations that his wife and child wanted to kill and eat him, trapping him by insisting that Nathan needed to be punished. Members of the jury, Mr. Ray has been trapped for years by schizophrenia in a mind he can't trust to tell him what's real and what isn't. And for Mr. Ray, there's no escaping that trap. Today, the prosecution must prove to you beyond a reasonable doubt that Mr. Ray killed Nathan. And like I said, we're not here to convince you he didn't. Instead, we're here to prove to you why Timothy Ray should be found not guilty by reason of insanity. After you hear the evidence presented today, two things will be clear. First, Mr. Ray was suffering from schizophrenia on October 17th, 2018. And second, that Mr. Ray's schizophrenia stopped him from understanding the wrongfulness of his actions. So let's take a look at the first thing that the evidence will show, that Timothy Ray was suffering from schizophrenia the day Nathan died. But to understand that, we have to go back to Mr. Ray's childhood. From the moment he was born, Timothy Ray was set to develop a severe mental illness. His mother was cruel and abusive, refusing to feed him, leaving him in cold baths for hours, and eventually abandoning him when he was 3 years old. He began hearing voices at 10, and seeing hallucinations by the time he was 23. By 2017, the year before Nathan's death, Mr. Ray's ex-wife and his primary care doctor were worried about his mental health. Today, you'll also hear from Dr. Shane Riley, a forensic psychiatrist with over 20 years of experience diagnosing and treating people with mental illnesses. Dr. Riley will tell you the symptoms that Mr. Ray was suffering from: hearing voices, delusions, and drastic mood swings. They're all common signs of schizophrenia, a mental disease that can make it difficult or even impossible for a person to maintain their connection with reality. And this takes us to the second thing that the evidence will show: that Timothy Ray's schizophrenia prevented him from understanding the wrongfulness of his actions. You'll hear about what happened when Mr. Ray was pulled over after killing his son. Officer Peyton Wentz will tell you that the night she stopped Timothy Ray at a DUI checkpoint, she knew something was off right away. He was frantic. He reeked of body odor. He accused Officer Wentz of being in the CIA. He got out of his car and began doing jumping jacks in the middle of the street. And he didn't stop even when Officer Wentz pulled her gun. When Detective Booth, the detective assigned to investigate Nathan's disappearance and death, showed up at the checkpoint, Officer Wentz made it a point to tell him about Mr. Ray's strange behavior. But Detective Booth will be forced to admit that despite the information Officer Wentz provided, he didn't spend much time looking into why Timothy Ray killed his son once he admitted what he'd done. He completely disregarded Mr. Ray's statements about the voices that told him his wife and son were plotting against him, and that they told him to punish Nathan. And despite Mr. Ray's erratic behavior in the interview room, despite being told that Mr. Ray was acting crazy at the traffic stop, despite Mr. Ray insisting Detective Booth was a CIA agent, Detective Booth never followed up on Mr. Ray's mental state. There was a recording of that interview that would allow anyone watching to both hear and see exactly how Mr. Ray was acting. But you won't be able to see that recording because Detective Booth decided not to save it, deciding that a transcript was enough. And as a result, you'll read, but you won't be able to see Mr. Ray begging Detective Booth for help, or Detective Booth responding by saying, "You're a piece of shit, Tim. You'd be better off dead." And why did Detective Booth act like this? Because while he may be a good, objective investigator in many cases, this case was different. In this case, Detective Booth knew both the suspect and the victim. You see, Detective Booth's child and Nathan were teammates on the same soccer team. Members of the jury, there's nothing easy about this case. But at the end of this trial, it will be clear that Mr. Ray is not a depraved, calculated killer. He is a man troubled, tormented, and trapped in a mind he can't trust. That's why at the end of this trial, my co-counsel will ask you to return the only fair verdict, the only just verdict, and the only verdict supported by the evidence, that Mr. Ray is not guilty by insanity.
Thank you, defense counsel. Okay, so now before the state calls its first witness, I'm going to ask that everyone switch to gallery view. Again, it's the same button in the top right of your screen, and that'll allow the attorneys and witnesses to be heard at the same time. Okay, so if the state is ready, feel free to call your first witness.
Yes, Your Honor. The state calls Detective Booth to the stand. Would you please introduce yourself?
My name is Detective Blake Booth.
Where do you work, Detective Booth?
I'm a detective at the Skelton Police Department.
How long have you worked for the Skelton Police Department?
A while. I've been there for 23 years,
How long have you been a detective?
12 years.
Detective Booth, why are you here today?
I'm here today to testify because I was the lead detective in the Nathan Ray case.
How did you become involved with Nathan Ray's case?
I first got involved when Nathan's mother, Jessica Ray, filed a missing persons report with the Skelton Police Department, and the report was filed with me.
Who was the suspect on that missing persons report?
Timothy Ray.
Do you see Timothy Ray in court today?
He's seated at defense counsel's table.
Let the record reflect that Detective Booth has identified the defendant, Timothy Ray.
The record will so reflect.
Yes, Your Honor. Detective Booth, I know that you said that that missing persons report was filed with you. Did you have enough time to adequately review that report?
I did.
If I showed you that report today, would you recognize it?
I would.
Directing court and counsel to what has been previously marked and admitted as Exhibit 7 on page 54, and to what has been previously marked as Exhibit 29 on page 106. Detective Booth, what is Exhibit 7?
Exhibit 7 is the missing persons report that Jessica Ray filed for Nathan Ray.
What is Exhibit 29?
Exhibit 29 is the photograph of Nathan Ray that was attached to the missing persons report.
Is Exhibit 29 a fair and accurate depiction of Nathan Ray?
It is.
Has Exhibit 29 been changed or altered in any way?
It has not.
The state offers Exhibit 29 into evidence.
Any objection from defense?
Yes, Your Honor. Under Federal Rule of Evidence 403, may we approach?
Yes.
Your Honor, the probative value of this evidence is low, as we have already stipulated admissibility to the autopsy report, which has Nathan's name and manner of death. There is no probative value in this photograph, and there is no question of who the victim is or any question of identification in this case. However, the prejudicial effect of this evidence is high, as the photo is only being used to show the jury a smiling photograph of the victim and is being used to inflame the passions of the jury.
So I'll turn it over to the state. Do you have a response? What's the purpose for the video or the picture of Nathan?
Yes, Your Honor. The purpose is that this photograph was attached to the missing persons report that Detective Booth has just told you about that Jessica Ray turned in for her son, Nathan Ray. This photograph of Nathan Ray was used to help identify the body that he will later get into was found in Brandywine State Park. And they used this photo of Nathan Ray to identify his body in this investigation. Further, Your Honor, as the prosecution, this is our victim. The jury deserves to see the face of our victim in today's case to fully understand why we are here today and who we are here today for.
Okay, I'm going to overrule the objection and admit the exhibit.
Yes, Your Honor. Permission to publish.
Go ahead.
Detective Booth, how old was Nathan Ray when this missing persons report was filed?
He was just 6 years old.
Did you ever find Nathan Ray?
Yes, ma'am, we did. We found him in Brandywine State Park.
And how did you find Nathan Ray? What state was he in?
When we found him, he was wrapped in a large black trash bag in a shallow grave, and you could still see his shoes sticking out of the bag.
And where did you find Nathan's body?
In the woods at Brandywine State Park.
When you found Nathan's body, did you take photographs of that scene?
We did.
Directing court and counsel to what has been previously marked and admitted as Exhibit 21 on page 98 of the case file. Permission to publish, Your Honor.
Go ahead.
Detective Booth, what are we looking at in this photograph?
This is how we found Nathan Ray's body in Brandywine State Park.
Where is Brandywine State Park?
It's in Skelton.
Now, Detective Booth, I want to talk to you more about your investigation into the defendant. How did this investigation begin?
So like I said, we got the missing persons report filed with us from Jessica Ray. And then I got a call that there was a suspect connected with the missing persons report stopped to the DUI checkpoint.
What did you learn when you arrived at that DUI checkpoint?
So when I got there, I learned that Timothy Ray had been stopped at the DUI checkpoint and he refused to give over his license and registration. And then he started kind of acting strange. And that's all I really found out right when I got there.
What did you see when you got to the DUI traffic checkpoint?
So I just kind of looked at the scene and then his car was still sitting there. So I looked in his car.
Was his car ever searched in your investigation?
Yes, ma'am, it was after we got a warrant.
Did you take photographs of the car when it was searched?
We did.
Directing court and counsel to what has been previously marked and admitted as Exhibit 23, which is on page 100 of the case file. Permission to publish, Your Honor?
Yes, is this already in evidence?
Yes, Your Honor. It was admitted in pretrial.
Okay, that's what I thought. Go ahead.
Detective Booth, once it's published, what are we looking at in this photograph?
So you can see 2-gallon jugs of bleach, a shovel, a box of trash bags, and a booster seat.
Well, Detective Booth, did you do anything else while you were at that DUI traffic checkpoint?
Yes, ma'am. We told Nathan Ray that he was under arrest and that we needed to take him to the station to ask him some questions.
Did you mean Timothy Ray, Detective Booth?
Yeah, yes, ma'am. Sorry, Timothy Ray.
Of course. And what did the defendant do when you told him you were arresting him?
He didn't really do much. He just told me he understood and he wanted to tell me everything.
Now, what was the first thing that you did when you took the defendant to the police station for questioning?
Like we always do before we start asking questions, we get our suspects to sign a Miranda waiver.
Directing court and counsel to what has been previously marked and admitted as Exhibit 4, which is on page 45 of the case file. Detective Booth, did the defendant ever indicate to you that he understood what was going on at the police station?
Yes, ma'am, he did several times. He told me verbally, I understand, and then he signed the Miranda waiver, which says that he understood.
Now, Detective Booth, let's talk about your interview with the defendant. What did you learn during this interview?
I learned that the defendant strangled his son Nathan Ray to death with a belt and then took his body to Brandywine State Park and buried it in a shallow grave.
Now, you just told us that the defendant confessed to murdering his son by strangling him with a belt. Were you ever able to locate that belt?
Yes, ma'am, we were.
Was a photograph of that belt taken when you found it?
It was.
Directing court and counsel to what has been previously marked and admitted as Exhibit 27, which is on page 104 of the case file. Permission to publish, Your Honor?
You may. Go ahead.
Detective Booth, what are we looking at in this photo?
This is the belt that Timothy Ray used to strangle his son Nathan.
And where did you find this belt?
We found it in Nathan Ray's bedroom at Timothy Ray's house.
And where did the defendant tell you that he strangled his son to death?
The defendant told me he strangled Nathan in Nathan's bedroom.
Now, Detective Booth, this interview of the defendant, was it video recorded?
It was.
Do you have a copy of that recording today?
No, ma'am, I don't. So the way it works is there's a transcript of the recorded interview, and usually I just use that, and I didn't really see the point in keeping the audio video recording. And after 30 days, if we don't request a copy, it's wiped off the servers.
Now, Detective Booth, I know that you told us earlier that you found Nathan's body in Brandywine State Park, but did you ever find any other evidence of the defendant trying to dispose of his son's body?
Yes, ma'am. We got a warrant to search the defendant's phone and found a collection of Google searches.
Directing court and counsel to what has been previously marked and admitted as Exhibit 10, which is on page 57 of the case file. Permission to publish, Your Honor?
You may.
Detective Booth, what did the defendant search for on his phone?
He searched for countries that don't extradite for murder charges, how to get rid of a body, and will bleach destroy a body.
Detective Booth, what all did you say you found in the defendant's car?
So we found large garbage bags, a shovel, and 2-gallon jugs of bleach.
Detective Booth, moving on in your investigation, was an autopsy ever done on Nathan's body?
Yes, ma'am, it was.
Were you there during the autopsy?
I was not, but I reviewed the report as a part of my investigation.
Directing court and counsel to what has been previously marked and admitted as Exhibit 6, which is on page 53 of the case file. Detective Booth, what is Exhibit 6?
This is the autopsy and medical examiner's report of Nathan Ray.
What does the autopsy report say caused Nathan's death?
Asphyxiation.
What does that mean?
That means that someone's oxygen supply was cut off until they stopped breathing.
Hang on, Detective Booth. I think there's an objection. Is there an objection from defense?
Yes, Your Honor. Improper opinion. May we approach?
Yes.
Your Honor, Detective Booth is not here as an expert for the prosecution and therefore cannot testify as to what asphyxiation means.
Do you have a response, prosecution?
Yes, Your Honor. Although this detective is a lay witness, he has just told us that he reviewed the autopsy report, even though he was not present. He reviewed it, and of course, is a detective, so he's very familiar with the different ways that people murder people by. So he knows what asphyxiation means and knows exactly what that means to be able to tell the jury.
Defense, do you have a response to that?
Yes, Your Honor. The prosecution has not laid any foundation to show that Detective Booth has ever dealt with an asphyxiation case prior to this trial.
Okay, I'm gonna allow the response just because I don't think it's disputed that Nathan was strangled and it's in the autopsy report. So I'm gonna overrule the objection. You can continue.
May we move back into the presence of the jury, Your Honor?
Yes.
Detective Booth, tell us again, what does asphyxiation mean?
It means that someone had their oxygen cut off until they stopped breathing and died.
Were there any other injuries on Nathan's body?
Yes, ma'am. He had some bruises, and he had specifically some bruises on his neck that were probably about 1.5 to 2 inches wide.
Was the autopsy report consistent with what the defendant told you in your interview with him?
Yes, ma'am. Given the cause of death was asphyxiation and the bruises that were on his neck, it shows that Timothy Ray did strangle Nathan to death with his belt.
Nothing further.
Okay, defense, are you prepared for cross-examination?
Yes, Your Honor.
Okay, whenever you're ready, go ahead.
Detective Booth, you knew Mr. Ray before this investigation, hadn't you?
For a couple months, yeah.
You also knew Mr. Ray's son, Nathan.
Yeah, his son was on my son's soccer team.
So you'd see Mr. Ray at practices and games.
Yeah, here and there.
And it had to be concerning when you learned that Mr. Ray's son was missing.
Well, every missing persons report is concerning to me.
Well, it was also concerning when you learned that Mr. Ray was suspected of taking the boy.
Again, any suspect is concerning in a case like this.
When you got to the checkpoint where Mr. Ray was stopped, you spoke with Officer Wentz.
I did.
That's the officer who initially stopped Mr. Ray.
That's right.
Officer Wentz told you that Mr. Ray was, quote, acting crazy.
Yeah, he told me he started acting strange after he tried to get him out of the car.
Well, so crazy that she felt he needed medical attention.
Yeah, he started acting crazy after he got out of the car.
Perhaps my question wasn't clear. Officer Wentz said that he was acting so crazy that she felt Mr. Ray needed medical attention.
She did say that.
Officer Wentz also told you that she saw several items in the back of Mr. Ray's car.
That's right.
The shovel,
Yep.
bleach bottles,
Yep.
and the plastic bags.
That's right.
knowing that Mr. Ray's son was missing, those items had to make you suspicious.
Yeah, and my suspicions were confirmed when he admitted to strangling his son to death.
That's when you saw those items, that's why you took Mr. Ray down to the police station.
Yes.
And it was during that interview that you learned your child's teammate was dead.
Yes.
That had to be hard for you.
Well, any homicide investigation is hard for me.
Well, Detective Booth, you actually lost your temper during your interview with Mr. Ray.
I'm not sure what you mean.
Well, you called him a piece of shit.
Well, anybody that will strangle their son to death with a belt is a piece of shit, but that's my personal opinion and it does not affect my professional.
You also said he'd be better off dead.
Yeah, I did. Again, I mean, that's my personal opinion, but my personal views do not affect my professional views.
Well, you'd agree your personal opinion clouded your judgment in this case.
No, it did not.
Well, it is fair to say that Mr. Ray made some unusual comments during your interview.
I mean, he said a lot of stuff, yeah.
He asked if you were in the CIA.
Yeah, that was after he knew that he was under arrest for killing his son.
And he mentioned hearing voices the morning he killed Nathan.
Yeah, after he was under arrest for killing his son.
So that's a yes.
Yeah, after he was arrested for killing his son.
Well, specifically, Mr. Ray told you that, quote, they told him he needed to make Nathan understand they couldn't let him his mother couldn't let him trick him.
And that's what he said, yeah.
And that they told him Nathan needed to understand that he couldn't, that they told him that Nathan's mother tricked Nathan into spilling the juice.
Yeah, I think that's what he told me.
In fact, he used that word they repeatedly.
Yeah, he did. And then he called me by name at the end of the interview as well, so.
And he used that word they about 6 times.
I mean, yeah, sure.
But you never asked Mr. Ray who they were, did you?
I didn't feel like I needed to. He had already told me he strangled his son to death.
After you found Nathan's body, you spoke with Nathan's mother, Jessica Ray.
Yeah, I did. It was a pretty tough phone call.
Mrs. Ray told you that she should have never left Nathan alone.
Objection, hearsay.
You have a response?
Yes, Your Honor. This falls under the exception of excited utterance.
Prosecution, do you have a response to that?
May we move outside the presence of the jury, Your Honor?
Yes.
Your Honor, we do not know if Jessica Ray was excited in this moment. We have no idea what she was thinking. This was over a phone call with Detective Booth.
Defense?
Your Honor, Detective Booth just testified that he called Mr. Ray after they found Nathan's body. And that's when Detective Booth actually told Jessica Ray that they found Nathan, her only son that was dead. Of course, she's going to be in an excited state at that time.
And what's the exact statement that you're wanting Detective Booth to state or to elicit?
That she should have never left Nathan alone with Mr. Ray when he was acting strange.
I'm going to sustain the objection.
Yes, Your Honor. And Detective Booth, when you called Mrs. Ray, she also said that she knew Mr. Ray was going crazy.
Can you repeat that?
When you called Mrs. Ray, she also said that she knew Mr. Ray was going crazy.
Objection, hearsay.
Do you have a response to this, counsel?
Yes, Your Honor. We are not using this for the truth of the matter asserted, but to simply show that Detective Booth was put on notice that there may have been something wrong with Mr. Ray that required him to either further investigate or contact a medical professional.
Do you have a response?
Yes, may we move outside the presence of the jury, Your Honor?
Yes.
Your Honor, this is more prejudicial than probative as the jury might take this to be true, that she really thought that the defendant was going crazy. However, she's a lay witness. She has no idea about any mental illness or what he might be suffering from. So this is a question of fact for the jury to decide, not this detective or this court.
I'm going to allow it. The jury can be instructed with a limiting instruction on how to use this evidence, not for the truth, but the effect it had on Detective Booth. Go ahead.
Yes, Your Honor.
So Detective Booth, Mrs. Ray told you that she knew Mr. Ray was going crazy,
Yeah, that's what she said.
but you didn't ask her what she meant when she said Mr. Ray was going crazy,
No, I did not.
or how long he'd been acting that way.
I didn't think it was necessary. He had just told me he strangled his son to death with a belt.
You didn't think it was necessary to ask whether whether Timothy Ray was going crazy?
Well, my job as a detective in homicide is to solve the killing. And when Timothy Ray told me that he strangled his son to death with a belt, the case was solved.
Detective Booth, as an experienced homicide detective, it is important to know whether a suspect is mentally ill.
I mean, yes, but when you have somebody admit to the crime, that's really what I'm there for.
But you know that in certain crimes, mental illness can be a defense.
I'll leave that up to you lawyers in the courts. That's not my decisions.
Now, Detective Booth, Skelton Police Department has specific directives for preserving evidence,
Yes, we have to preserve relevant evidence.
and the directives say that all interviews should be recorded on video.
Yep.
And you made sure that your interview with Mr. Ray was video recorded.
Yes, I always follow protocol.
Skelton Police Department also has a procedure set up to preserve interview recordings.
Yeah, they're saved for 30 days, and if there's no request, they're wiped from the server.
And so to make a request, the detective just has to send a request to the IT department.
Yep.
And like you mentioned, the detective doesn't have to make that request the same day as the interview.
No, they do not.
You have 30 days to make that request.
Yeah, we do.
But you never requested that your interview with Mr. Ray be saved.
Well, I follow the protocols and directives that the police department sets out, and it's not required, and we have a transcript, so.
But you didn't follow the directive that said to preserve all interview video recordings.
No, we preserved it for 30 days, but after that time, under the directives, we're not required.
Even though there's a Skelton Police Department directive telling officers not to destroy evidence?
Well, I did not destroy it. So the way it works is there's a database, I guess, of the interviews. And if you don't request a copy in 30 days, then they're deleted. So I didn't delete it. I had a transcript and I just didn't preserve the recording because it wasn't necessary.
And because you decided that it was not necessary to preserve that video recording, we can't see Mr. Ray's demeanor when he asked if you were in the CIA.
No.
We also can't see his demeanor when he talked about the voices he said he was hearing.
No, but you can see on the transcript everything he was saying.
We also can't see how angry you were when you called Mr. Ray a piece of shit.
I'm not the one on trial here today.
Your Honor, I have no further questions.
Okay, thank you. Any redirect?
Yes, Your Honor, just briefly.
Go ahead.
Detective Booth, did the fact that you knew the defendant or Nathan Ray affect your investigation in this case?
Absolutely not. I mean, I did say he was a piece of shit and things like that, but anybody that kills their kid, really, I would say is a piece of shit. But my personal opinions do not affect my professional conduct.
Nothing further. Your Honor, may this witness be excused?
Yes, thank you. Any further witnesses on behalf of the state?
Yes, Your Honor. At this time, the state would like Dr. Mac LaGreca to take the stand.
Okay, whenever you're ready, counsel.
Could you introduce yourself to us?
My name is Dr. Mac LaGreca.
Dr. LaGreca, what do you do for a living?
I'm a forensic psychiatrist.
How long have you been a forensic psychiatrist?
For 26 years.
So, Dr. LaGreca, where did you go to school to become a forensic psychiatrist?
I went to medical school at University of Pennsylvania, and then completed my psychiatric residency at UCLA.
Dr. LaGreca, in your 26 years of experience, what kind of cases have you handled?
I've worked with a wide variety of cases and diverse patient population, including schizophrenia.
Now, Dr. LaGreca, have you ever testified as an expert before?
Yes, I have in 7 other cases.
Have any of those trials been regarding schizophrenia?
Yes, 3 of those.
Your Honor, at this time, the state offers Dr. Mac LaGreca as an expert in the field of forensic psychiatry.
Any objection from defense?
We have no objection, Your Honor.
Okay, go ahead.
Dr. LaGreca, were you able to reach an opinion in today's case?
Yes, I was.
And is your opinion based on reasonable or sufficient facts and data?
Yes.
And is your opinion based on reliable principles and methods?
Yes.
Were you able to apply those reliable principles and methods to the facts of this case?
Yes, I was.
And doctor, is your opinion to a reasonable degree of medical certainty today?
Yes, it is.
And in forming your opinion, what all did you review?
I reviewed all the materials in the case file, including Dr. Riley's report, interviews with the defendant and the officers involved. Also reviewed all of the defendant's medical history, medical records, and I consulted the DSM-5 criteria.
Now, doctor, after reviewing all of that material, what is your opinion today?
It is my opinion that Timothy Ray, the defendant, was not suffering from schizophrenia, and his actions post-arrest were consistent with malingering.
Doctor, you just used a word, malingering. What exactly does that mean?
So malingering is a sort of technical term that means that a person is creating or faking a set of symptoms for secondary gain. And in this case, it would be for the purpose of creating a legal defense.
Now, doctor, after reviewing all of the materials in today's case, what was the first indication that this defendant was faking his symptoms?
Well, there were a lot of inconsistencies in when I reviewed the case that just didn't add up, and all of these inconsistencies pointed to the fact that the defendant did not really have a diagnosis of schizophrenia, but rather all of his actions were consistent with malingering.
Now, when was the first time that you noticed in this case that the defendant pointed towards a malingering diagnosis rather than a schizophrenic one?
So for the first time I noticed it was, at the DUI checkpoint where he was interviewed by the officer. He really didn't show any signs of schizophrenia initially, but when he was asked to hand over his license, his registration, things that would point towards him getting in trouble for his actions, he started to act strange, asked the officer if he was in the CIA, things like that. After the fact, he realized he might get in trouble for his actions.
Dr. LaGreca, outside of the inconsistencies and the fact that this defendant started acting strange at the DUI checkpoint, was there anything else that pointed towards faking symptoms rather than a schizophrenic diagnosis?
Yes. The main thing I would say is that, he started mentioning or reporting all of his symptoms to Dr. Riley, who was also the only physician he's ever reported these symptoms to. After the fact, he was in jail. So he never reported his symptoms before to any other physician. And so the fact that he did so to Dr. Riley after he was sitting in jail, facing charges, that was a major criteria that led to my diagnosis of malingering.
Dr. LaGreca, was there anything in his interview with Detective Booth that indicated to you that the defendant might not be suffering from schizophrenia?
Yeah, in his meeting or interview with Detective Booth, he was, creating or showing signs of schizophrenia initially, But then, as soon as he realizes that Detective Booth isn't really buying what he's saying and his actions, and the fact that he did actually kill his son, he realizes that he has to, appeal to a detective.
Objection,
Booth.
Your Honor. Speculation.
Do you have a response?
Yes, Your Honor. May we be heard outside the presence of the jury?
Yes.
Your Honor, this is an expert today who's testifying to what in his review of the case indicated to him that this defendant was malingering. If I may, Your Honor, Dr. LaGreca is about to testify to the fact that at the end of this interview with the defendant called Detective Booth by name after pretending, in Your Honor, that he did not know who Detective Booth was, pretending that he thought he was in the CIA. But the very last thing that this defendant said was calling Detective Booth by name and requesting help. Dr. LaGreca relied on this in forming his opinion today as to whether or not the defendant was malingering, and therefore this is not speculation, Your Honor.
Mr. Mills, do you have anything you want to respond?
Yes, Your Honor. The expert witness is testifying as to what Mr. Ray is thinking inside of his head. He just stated that he realized it wasn't adding up and he needed to change up his strategy. The expert can't testify as to what exactly Mr. Ray was thinking. He can testify to what the different actions indicate, but he can't specifically say, because of this action, the witness or Mr. Ray was thinking X, Y, and Z.
I'm going to allow it since he's an expert witness. However, you can explore what you've just talked about on cross-examination.
Yes, Your Honor. May we move back inside the presence of the jury?
Yes, go ahead.
Dr. LaGreca, in this interview of the defendant, what was the last thing that the defendant told Detective Booth?
So he said, he mentioned him by first name. He said, "You have to help me, Blake," and you said that you would help me. So that was what I was referring to, and when I said he sort of appeals in a different way to Detective Booth.
So, Dr. LaGreca, you mentioned earlier that you reviewed everything in today's case, but were you able to review the defendant's medical history?
Yes, I was.
And Dr. LaGreca, if I was to show a demonstrative of the defendant's medical history, would this assist you in explaining your opinion to the jury today?
Yes.
Your Honor, at this time, the state would like to publish a demonstrative via the share screen function. We have talked to opposing counsel prior to trial regarding this particular demonstrative.
Okay, and did they have any objection?
No,
We
Your
don't
Honor.
have any.
Oh, sorry.
Okay, perfect. Go ahead.
So, Dr. LaGreca, in reviewing the defendant's medical history, when was the first time that he saw a medical provider?
He saw Dr. Riley in 2010, shortly after he was discharged from the military.
Was that prior to his discharge of the military, Dr. LaGreca?
Yes.
Now, in 2010, what kind of symptoms did the defendant report to Dr. Riley?
He reported symptoms of anxiety, depression, high levels of stress, and general difficulty sleeping.
In this evaluation with Dr. Riley, what kind of symptoms did the defendant deny?
He denied hallucinations, delusions, suicidal ideations.
Did he claim to hear voices in 2010?
No, he did not.
So Dr. Riley, Dr. LaGreca, I'm so sorry. In 2010, did Dr. Riley reach a diagnosis?
He did reach a diagnosis. He reached the diagnosis of generalized anxiety disorder.
So Dr. LaGreca, in reviewing the defendant's medical history, when was the next time he saw a doctor?
He saw his primary care physician in 2011.
Who's his primary care physician?
Dr. DiGiuseppe.
In 2011, what kind of symptoms did the defendant report to Dr. DiGiuseppe?
He reported the similar symptoms as before, anxiety, depression, difficulty, things like that.
Now, doctor, at this visit in 2011, did the defendant claim to hear voices?
No, he denied any hallucinations, delusions, suicidal thoughts.
And in 2011, did Dr. Di Giuseppe come to a diagnosis?
No, she did not.
After this visit with Dr. Di Giuseppe in 2011, when was the next time that the defendant saw his primary care physician?
2014.
In 2014, what did the defendant report?
The same symptoms as before, anxiety, depression, sleep issues, and he denied hearing voices, hallucinations, suicidal thoughts, basically anything that would point towards a diagnosis of schizophrenia.
After denying all of these symptoms, did Dr. Di Giuseppe come to a diagnosis?
No.
Now, doctor, I want to talk to you about the next time that the defendant saw a treating physician. When was that?
2016, I believe.
And who did he see in 2016?
The same doctor.
Thank you, doctor. What kind of symptoms did the defendant report at this visit?
He reported the same symptoms again, anxiety, depression, high levels of stress, and denied any hallucinations, delusions, suicidal thoughts.
So in this visit, doctor, he denied all of those symptoms?
Yes.
And at this visit, did Dr. Di Giuseppe diagnose the defendant with any medical treatment?
No formal diagnosis.
So, doctor, after this visit in 2016 or 2017, when was the next time that the defendant was treated by any physician?
I believe he saw Dr. Riley in 2019.
So he saw Dr. Riley in September 2019?
Yes.
And what kind of symptoms did the defendant report to Dr. Riley in September 2019?
So at that time, he reported, that he heard voices. He was having auditory hallucinations, visual hallucinations his whole life, and he had these racing thoughts, difficulty controlling his emotions, paranoid delusions.
Had the defendant ever reported these symptoms before?
This was the first time he was reporting these symptoms.
Now, doctor, did the defendant ever see another physician after meeting with Dr. Riley in September of 2019?
Yes, I believe he saw another doctor, Narshi Simhan, in jail.
And when was this visit?
It was after the September 2019.
So in October of 2019, the defendant saw Dr. N. What kind of symptoms did he report at this time?
Same symptoms he reported to Dr. Di Giuseppe, anxiety, depression, stress, but he, denied all the other symptoms that he reported to Dr. Riley, the hallucinations, the delusions, the suicidal thoughts, and stuff like that.
So, doctor, looking at the defendant's medical history in a whole, is there anything that could explain why the defendant would report hearing voices and suffering from paranoia in September of 2019, but not October of 2019?
The only thing that would explain that is that he's faking it, and this would be a diagnosis of malingering.
And what happened in October of 2018?
What do you mean by that? Oh, in October 2018, he killed his son.
So, Dr. LaGreca, looking at this in its entirety, what is your opinion today?
My opinion is that the defendant did not suffer from a diagnosis of schizophrenia, and that his actions post-arrest are consistent with malingering.
Your Honor, no further questions for this witness.
Thank you. Is defense ready for cross-examination?
Yes, Your Honor.
Okay, whenever you're ready, go ahead.
Doctor, this isn't the first time you've testified as an expert witness.
No, it's not.
It's the 8th time.
Yes.
And the 7th you've testified for the prosecution.
Yes.
In this case, the prosecutors hired you to give your opinion about Timothy Ray's mental health the day he killed Nathan.
To give my expert medical opinion, yes.
You charged them $500 an hour to review the materials.
As is customary.
Well, materials that took you 25 hours to review
Yes,
for a total of $12,500.
yes,
Your testimony here today costs an additional $1,750
yes, those are the fees.
for a total of just over $14,000.
I believe so.
Now, one of the things you considered when forming your opinion was the Diagnostic and Statistical Manual 5th edition, or DSM-5.
Yes,
The DSM-5 is published by the American Psychiatric Association,
yes,
and it's used by psychiatrists and psychologists throughout the country.
yes,
Now, someone may be diagnosed with schizophrenia if they experience at least 2 of the listed symptoms for at least 1 month.
yes,
Delusions are one of those symptoms.
yes,
A delusion is a strongly held belief that's not rooted in reality.
correct.
Doctor, you reviewed like you said, you reviewed a transcript of Dr. DiGiuseppe's testimony for your report.
Yes,
And as you said on direct examination, she was Mr. Ray's primary care doctor.
yes,
And in that transcript, she talks about her various visits with Mr. Ray.
yes,
With her last visit, as you just testified to, being in 2016 or 2017.
yes,
And during that visit, she said that she was worried about Mr. Ray when she saw him.
yes, she did mention that.
In fact, she was so concerned that she asked Mr. Ray if he was thinking about hurting himself.
Yes,
And in response to the doctor's concern, Mr. Ray called her, and I quote, a goddamn bitch,
yes, I believe so.
and accused her of plotting with his ex-wife against him
Yes,
and of listening to his phone calls.
yes.
Doctor, you're not aware of any evidence that Dr. DiGiuseppe ever spoke to Mrs. Ray.
I can't comment on that.
Well, doctor, to be clear, you didn't come across any evidence with the materials you were given that indicates Mrs. Ray ever spoke with Dr. DiGiuseppe.
It wasn't mentioned in the materials, no.
Or that the doctor was secretly listening to Mr. Ray's phone calls.
Once again, it wasn't mentioned in the materials.
Or on the night he was arrested, Mr. Ray told the police that the CIA was looking for him.
Objection, Your Honor.
On
May
what?
we be heard outside of the presence of the jury?
Yes.
Hearsay. Everything that the defendant said is hearsay.
Okay, Mr. Mills, do you have a response?
Yes, Your Honor, we're not using Mr. Ray's statements for their truth. We're not trying to prove that the CIA was indeed looking for him. They go towards his state of mind. They are circumstantial evidence of his schizophrenia he was suffering at the time.
I agree. I'm going to overrule the objection.
Yes, Your Honor.
So again, doctor, on the night he was arrested, Mr. Ray told the police that the CIA was looking for him
Yes,
for terrorism.
yes,
Mr. Ray also accused the police officers with him that on that night of being CIA agents.
yes,
Again, doctor, as far as the materials you reviewed for this case, you didn't find any evidence that the CIA was actually looking for him
correct,
or that Timothy Ray was some terrorist
correct,
or that Detective Booth or Officer Wentz are really CIA agents.
correct.
Now, doctor, hallucinations are another symptom of schizophrenia, correct?
Yes,
You're aware that Mr. Ray told Dr. Riley that he'd been hearing voices since he was 10 years old.
yes, that's what was reported for the first time after he was sitting in jail and facing all these charges.
But to be clear, Mr. Ray did tell Dr. Riley that he'd been hearing these voices.
Yes, it was reported once again after the fact that he was in jail facing all these charges.
And that while Mr. Ray was in the Army, his commanding officer reported that Mr. Ray was seeing things.
Objection, Your Honor.
On what grounds?
Hearsay. May we move outside the presence of the jury?
Yes.
Your Honor, anything that Dr. or Officer Cruz testifies to, or does not testify to rather, tells Dr. Riley is hearsay.
Okay, Mr. Mills, do you have a response?
Yes, Your Honor, this is an expert witness and he relied upon Officer Cruz's as well as other hearsay evidence to form his opinion in this case. And I'm just merely asking him about that opinion.
Okay, and prosecution, do you have a response to that?
Yes, Your Honor. What Officer Cruz reports is to Dr. Riley, not Dr. LaGreca. Dr. LaGreca bases his opinion on the diagnosis made by Dr. Riley, not the opinion of Officer Cruz. The defendant denies everything said by the officer, Your Honor.
Did Dr. LaGreca take these statements into consideration in coming to his opinion?
Yes, Your Honor.
Okay, I'm going to allow it then.
And Doctor, while Mr. Ray was in the Army, his commanding officer reported that Mr. Ray was saying things.
I believe so.
Is that a yes?
Yes.
And on the night of his arrest, Officer Wentz reported that Mr. Ray appeared to be talking to people that weren't there.
Yes. After the fact that he realized he was he was going to get in trouble.
But to be clear, Officer Wentz did report these things.
Yes. After he
Doctor,
asked for the defendant's license, registration, and all that. Not initially, no.
Doctor, you also had a chance to review Mr. Ray's medical records from jail.
Yes.
And as you testified in direct, you knew that he saw the doctor in the facility in 2019.
Yes.
And when he saw the doctor prescribed Mr. Ray with a medication called Seroquel.
Yes.
Seroquel is an antipsychotic drug.
I do not believe so.
Well, Doctor, you did have a chance to review the materials of this case.
Yes.
And you are aware of the stipulation that was part of the materials saying that Seroquel is an antipsychotic drug used to treat certain medical records and mood conditions.
Yes.
So to be clear then, Seroquel is an antipsychotic drug.
Yes, it is an antipsychotic.
And it's used to treat bipolar disorder.
It's used to treat a variety of psychiatric illnesses, including bipolar disorder.
Another thing it could be used to treat is mania or depression associated with bipolar disorder.
Yes.
And it can also be used to treat schizophrenia.
Yes.
And doctor, as far as you know, Mr. Ray has never been diagnosed with bipolar disorder.
No, not that I know.
No further questions for this witness, Your Honor.
Okay, any redirects?
Your Honor, I would simply request to read in stipulation number 7 at this time.
Go ahead.
Seroquel is an antipsychotic used to treat certain mental conditions and mood conditions. Seroquel can be used to treat schizophrenia, bipolar disorder, and sudden episodes of mania or depression associated with bipolar disorder. A prescription of 300 milligrams of Seroquel could be used to treat any of these conditions. Your Honor, we have no redirect for this witness. May he be excused?
Yes.
And
oh, go ahead.
Your Honor, at this time the state rests.
Okay. So it looks like we're halfway. Before the defense presents their case, if they choose to do so, would either side or both sides like a brief recess?
Yes, Your Honor.
Okay, is 5 minutes okay or 10 minutes?
Before we break, Your Honor, may we have a time check?
Yes. During this recess, I'll give you guys 10 minutes. So during this time, meet and confer with your timekeepers. They should meet and confer with each other as well. And you can get the time check over the break, okay?
Yes, Your Honor.
All right, so I will see you back in 10 minutes. Okay, do we have everyone back?
Yes.
Okay. Do we have both sides or both parties for the prosecution? Perfect. Okay, so is everyone ready to proceed?
Yes, Your Honor.
And was everyone able to get a time check?
Yes, Your Honor.
Okay. So at this point, I'll turn it over to the defense. Do the defense have any witnesses they wish to call?
Yes, Your Honor, but first we would like to make a motion outside the presence of the jury.
Okay, go ahead.
Your Honor, pursuant to Federal Rule of Criminal Procedure 29, the defense moves for a judgment of acquittal, even interpreting the evidence in the light most favorable to the non-moving party. The prosecution has brought insufficient evidence to prove their charges today.
Okay, and the state, do you have a response?
Yes, Your Honor. Today, the state put on Detective Booth, who testified that this defendant confessed to strangling Nathan Ray. This jury saw the belt Nathan was strangled with and saw the screenshots that this defendant searched after strangling his son to death. Someone who does not understand the nature and consequences of their actions does not go through such lengths to hide what they have done. Your Honor, a reasonable juror could absolutely conclude that Timothy Ray is guilty of first-degree murder, and the defense's motion is due to be denied.
Okay, anything else, Ms. Rivera?
Yes, Your Honor. Specifically, the prosecution has failed to prove malice aforethought. As the prosecution just stated, they discussed events happening after Mr. Ray's son was killed, not at the time or before.
Your Honor, if I may be heard.
Go ahead.
The jury instructions state that in coming to their determination, a juror can use information from both before, during, and after the murder to conclude whether or not this defendant had the requisite mental state. Your Honor, we presented evidence of both during or before and after Timothy murdered his son, and a reasonable juror could absolutely conclude that Timothy Ray is guilty, Your Honor.
Okay, is the matter submitted?
Yes, Your Honor.
Okay, I'm going to deny the motion. Defense, you can call your first witness.
Yes, Your Honor. And before I apologize, but I must insist, can we have an official time check on the record, please?
Sure. Can we hear from the timekeepers?
Yes. For the state, I have that the remaining time is 24 minutes and 41 seconds.
Okay, and for the defense?
For the defense, there's 32 minutes and 26 seconds.
Okay, and do both sides agree?
Yes.
Yes.
Okay. All right, go ahead.
Thank you, Your Honor. May I proceed?
Yes, go ahead. Call your first witness.
The defense calls Officer Peyton Wentz to the stand. Hello. Please introduce yourself to the jury and tell us what you do for a living.
Hello, my name is Peyton Wentz, and I am a police officer for the Skelton PD.
How long have you been an officer for Skelton PD?
I've been with the department about 4 years now.
And what's your current assignment?
I work patrol, so I spend most of my shift patrolling the city and responding to radio calls.
Officer, were you working the night of October 19th, 2018?
Yes, my partner and I were working a DUI checkpoint in the city.
And at some point that night, did you meet Timothy Ray?
Yes, he was one of the drivers that drove through the checkpoint that night. I remember he looked pretty rough.
What do you mean?
Mr. Ray just looked bad. His hair was all messed up, his eyes were glassy, and his clothes were rumpled and stained, and he smelled terrible. I could actually smell him standing outside the car.
What happened when Mr. Ray drove up?
I asked him for his license and registration, but at first he wouldn't give it to me. He started arguing with me, saying that he forgot his wallet at home, but I could see that it was sitting right next to him, so I pointed that out to him.
What happened when you pointed out his wallet?
He then gave me his license and registration.
What'd you do after he gave you his license and registration?
I started to walk back to my patrol car to check out the information. And as I was walking back to my car, I took a quick look inside Mr. Ray's vehicle with my flashlight.
Why'd you take a look in his car?
At that point, I was suspicious. He had been acting odd.
You say odd. Did you think he was drunk?
No, it wasn't anything like that. He wasn't slurring his words or speaking slowly, and I didn't smell any alcohol. It was more just the way he looked and his defiance.
So what'd you do when you looked into his car?
Well, I saw that his car was a mess. There was trash everywhere. And I saw a box of trash bags, a shovel, and a couple containers of bleach on the back seat.
So after seeing these items, what did you do next?
I asked my partner to run a computer check on the information to see if there were any warrants or to check that Mr. Ray's license was valid. And then I went back to Mr. Ray's car to keep an eye on him.
What happened when you got back to Mr. Ray?
Well, out of the blue, he just started yelling at me and asking crazy questions.
Well, what do you mean?
He yelled at me, "Are you with the CIA?" And he told me that he knew the CIA was out to get him because they thought he was a terrorist. And he said he could hear CIA sirens coming to get him.
Officer, could you hear any sirens?
No, there were no sirens.
So what'd you do?
I spoke calmly to him. I explained I was not with the CIA. I tried to explain why we had pulled him over. And at that point, I asked him to step out of his car.
Did he follow your direction?
Eventually, he did keep asking to see my CIA credentials, but eventually, yes, he did get out of the car.
And what was his demeanor after he got out of the car?
He started moving really slowly, almost like a robot. He had this blank stare on his face. He wasn't making eye contact with me anymore. And he kept muttering to himself, "I'm a good father. I didn't mean it," over and over again.
What happened next?
Then he started doing jumping jacks.
Jumping jacks.
Yes, it was really weird. He said something about trying to get his son in shape and that he needed to get him to admit something he broke. And then it was like he looked at me like he was noticing me for the first time.
So what'd you do?
I asked Mr. Ray to stop moving around, but he kept on doing jumping jacks. So I drew my gun and ordered him to stop moving.
Did he stop?
Well, he stopped jumping, but then he started thrashing his head around uncontrollably, and he put his hands to his ears like he was trying to block out the sound. So that's when I decided I needed to handcuff him until I could figure out what was going on.
Now, after you handcuffed Mr. Ray, what'd you do?
My partner told me that Mr. Ray's plates had been flagged on a missing persons report about a little boy. So I told my partner to watch Mr. Ray, and I radioed dispatch about the stop. Detective Booth showed up about 20 minutes later.
What did Detective Booth do after he arrived?
He had me and my partner shut down the checkpoint and escort Mr. Ray back to the station in our patrol car.
As you took Mr. Ray back to the station, how was he acting on the drive?
He was crying and talking to himself.
Officer, did you ever tell Detective Booth about Mr. Ray's behavior when you pulled him over?
Yes. A couple days after we arrested Mr. Ray, Detective Booth interviewed me at the station to figure out what had happened before he arrived at the scene. It was at that point that I told him how bizarrely Mr. Ray was acting when I pulled him over.
Thank you, Officer Wentz. No further questions at this time, Your Honor.
Okay, cross-examination?
Yes, Your Honor.
Whenever you're ready, go ahead.
Officer Wentz, you're a patrol officer.
Yes.
You work with the Skelton Police Department,
Yes.
where you've worked for what, 4 years now?
That's correct.
And you went to the police academy to become a patrol officer, correct?
I did.
Where you took a variety of classes.
Yes.
You took classes on how to handle weapons,
Correct.
how to handle suspects.
Yes, including suspects who might be mentally ill.
That's right. You took a week-long training on mental illness.
Yes, on how to de-escalate situations with those who might be mentally ill.
Now, Officer Wentz, you'd agree with me that you're not qualified to treat patients.
No, I'm not a doctor.
You're not qualified to identify certain mental illnesses.
No, just the signs of what might be a mental illness and how to handle the situation a little differently.
Now, Officer Wentz, you're not a doctor, right?
No, like I said, I'm not a doctor.
You're not a psychiatrist,
Nope, like I said, not a doctor.
which means you're not an expert in schizophrenia.
No,
You're not an expert in malingering.
no.
But as a cop, you do know that sometimes people, they might lie when they think they're in trouble.
Sure.
They might lie about how fast they were driving.
Yes.
They might lie about how many beers they've had.
Yes.
They might even lie and try to tell you that the drugs aren't theirs.
Yes.
Now, officer, I want to talk to you a bit about what happened at that DUI checkpoint. When you stopped the defendant, you asked him for his license.
Yes.
He told you that he didn't have it.
Right. That's when I said I saw it sitting next to him, so I told him that.
That's right. You had to tell him that you could see his wallet.
That's correct.
And in your words, that was suspicious.
Yes.
You also asked him for his registration.
Correct.
He told you that he didn't have that either.
That's right.
But eventually he reached into his glove box and handed you that registration,
He did. Yes, eventually.
where it had been in his car the whole time.
Yes.
Now, officer, at this point, you start to walk back to your patrol car.
Yes.
Now, on your way, you shine your flashlight in his back seat,
Yes.
and that is when you see the shovel.
Yes. And some bleach and trash bags as well.
That's right, you saw bleach and trash bags all on top of a booster seat,
Yes, right next to a booster seat.
next to some Legos.
Yes, some toys were in there as well.
In your words, between this and his defiance, you're suspicious.
Yes, he was acting incredibly odd. I did not know what was happening.
So you walk back up to his driver window
Yes.
and have your partner run his information.
Yes, wanted to keep an eye on him, make sure I stayed close by to Mr. A.
Because you were scared that he might try to run off.
Yes.
Now, officer, up until this point, the defendant was speaking in clear sentences.
Yes.
Up until this point, he seemed to understand what you were asking of him.
Yes, other than being confused about his wallet.
I believe your words were that he was defiant about giving you his information.
Yes.
But it was only after you got his license and his registration that he mentioned anything about the CIA.
That's true.
It was not until after you got his license and his registration that he asked for your CIA credentials.
That's true.
It was not until after you got him out of his vehicle that he began to do jumping jacks.
That's true.
Officer Wentz, it was not until after the defendant gave you his license and his registration that he said anything about being a good father.
Right, that's true.
It was not until after the defendant gave you his license and his registration that he said, I am a good father. I didn't mean it.
Yes, that's correct.
Nothing further, Your Honor.
Okay, thank you. Any redirect?
No redirect, Your Honor. May this witness be excused?
Yes. Any further witnesses on behalf of the defense?
Yes, Your Honor. The defense calls Dr. Shane Riley.
Okay, go ahead.
Good afternoon. Please introduce yourself to the jury and tell us what you do for a living.
My name is Dr. Shane Riley, and I am a forensic psychiatrist with my own private practice here in West Carolina.
How long have you worked in the field of forensic psychiatry?
Over 20 years now.
Can you tell us what forensic psychiatry is?
Forensic psychiatry is the area of psychiatry that deals with mental illnesses and the justice system.
Where did you go to school?
I received my bachelor's degree from the University of Notre Dame. I then received my medical degree from the Uniformed Services University School of Medicine, or USU, where I graduated fourth in my class.
What did you do after medical school?
I completed both my residency and forensic psychiatry fellowship at Walter Reed National Medical Center.
You just mentioned USU and Walter Reed. Are you in the military?
Yes, I'm a major in the U.S. Army.
Where did you work after you completed your forensic psychiatry fellowship?
I taught as an associate professor of psychiatry at USU and was deployed to Iraq, where I was the primary psychiatrist and oversaw 20,000 soldiers.
What did you do when you returned from Iraq?
I worked as an associate professor of psychiatry for the residency program at Walter Reed and managed a psychiatric inpatient unit where I treated hundreds of patients with a variety of mental disorders, including schizophrenia. Eventually, I was promoted to deputy director of behavioral health.
Are you board certified?
Yes, I'm board certified by the American Board of Psychiatry and Neurology.
Have you ever been published in the field of forensic psychiatry?
Yes, I've written 15 peer-reviewed articles in the field of forensic psychiatry, and I wrote 2 specifically relating to schizophrenia.
Have you ever testified as an expert before?
Yes, 25 times total, and 18 times were in criminal cases.
Do you always testify on behalf of the defendant?
Most of the time I testify for the defense, but I have testified once for the prosecution.
Your Honor, at this time, we tender Dr. Riley as an expert in forensic psychiatry.
Any objection?
No, Your Honor.
Okay, go ahead.
Turning your attention to today's case, how did you get involved?
I was retained by your office to provide an opinion regarding whether and to what extent Mr. Ray suffered from any mental disorders at the time of Nathan's death.
How much do you charge for your time as an expert?
My usual charge is $450 an hour to review materials and $1,500 per day for my trial testimony, but I reduced my rate to $350 per hour to review the materials in this case.
Why did you lower your rate to review this case?
I treated Mr. Ray in 2010 when we were both stationed, so reviewing the materials was not quite as time-consuming, and he's also a fellow Army vet.
Were you able to form any opinions about whether Mr. Ray suffered from a mental illness on the day of Nathan's death?
Yes, I was.
What's the basis for your opinion?
My experience treating Mr. Ray, my review of his medical records, and my review of all materials on the exhibit list. I also conducted a clinical interview with Mr. Ray and interviewed his wife, his father, and his former boss.
Do you hold your opinion to a reasonable degree of medical certainty?
Yes, I do.
What is your opinion?
It is my opinion that Mr. Ray was suffering from severe schizophrenia at the time of Nathan Ray's death.
Dr. Riley, what is schizophrenia?
Schizophrenia is a mental disorder that causes people to suffer from symptoms like not being able to tell what is real and what is not. It can cause delusions and hallucinations, and can also cause disturbances in behavior and thought.
Does everyone suffer from schizophrenia in the same way?
No. Schizophrenia manifests on a spectrum. Some people can manage their symptoms with treatment, while others can experience symptoms so severe that it impairs their ability to understand the nature of their actions.
How does a doctor determine whether someone suffers from schizophrenia?
We compare the symptoms the patient has with the criteria in the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, or DSM-5.
Your Honor, I have a document which has been pre-admitted into evidence as Exhibit 17A. This item can be found on page 93 of the record. Dr. Riley, do you have a copy of Exhibit 17A?
Yes.
Do you recognize it?
Yes.
What is it?
It's a page from the DSM showing the definition and the criteria for schizophrenia.
Does Exhibit 17A accurately state the DSM-5 definition for schizophrenia as you relied on it in coming to your opinion?
Yes, it does.
Permission to publish Exhibit 17A for the jury?
Any objection?
No objections, Your Honor. This was pre-admitted.
Okay, go ahead.
Mr. Khan, can you call out the portion under diagnosis? Doctor, how many symptoms listed here in the DSM-5 does a patient have to show to be diagnosed with schizophrenia?
At least 2 of the 5 criteria for at least 1 month.
Based on your evaluation, how many symptoms does Mr. Ray suffer from?
Mr. Ray suffers from 3 of the 5.
Which 3 symptoms?
Hallucinations, delusions, and negative symptoms.
What did you do to verify that Mr. Ray actually suffered the symptoms he reported to you?
I observed him firsthand. I apologize. I observed him firsthand during an interview, and I'm sorry, can you please repeat the question?
Yes. What did you do to verify that Mr. Ray suffered the symptoms he reported to you?
Yes, I observed him firsthand during a clinical interview, and I reviewed his records. I also interviewed the people closest to him, including his wife, his father, and his former work supervisor.
I'd like to take those 3 symptoms you mentioned earlier one at a time. What evidence was there that Mr. Ray suffered from hallucinations?
Mr. Ray reported hearing voices, which indicates auditory hallucinations. He also reported seeing triangles on the wall, which can change shapes and colors, which constitute visual hallucinations.
How long did Mr. Ray say he's been suffering from hallucinations?
Mr. Ray reported that he had been hearing voices since the age of 10. He recently reported hearing male voices telling him to hurt other people. He said he began having the visual hallucinations at the age of 31, continuing through the time of Nathan's death.
You mentioned earlier that Mr. Ray was a patient of yours in 2010. What evidence was there of Mr. Ray's hallucinations at that time?
Yes, when I evaluated Mr. Ray in 2010, he had just been discharged from the Army. Mr. Ray's commanding officer reported that he was seeing things and that he was suicidal. We had to hospitalize him for 3 days.
What was your diagnosis in 2010?
Generalized anxiety disorder.
Why didn't you diagnose Mr. Ray with schizophrenia at that time?
At the time, Mr. Ray was not exhibiting all of the symptoms of schizophrenia, and he denied having hallucinations.
The second symptom you mentioned Mr. Ray suffers from are delusions. What are delusions?
Delusions are false beliefs that a person firmly holds, despite the fact that they are not based on reality.
What evidence was there that Mr. Ray suffered from delusions?
During my 2019 interview with Mr. Ray, he told me that in 2015, he was convinced that his wife and his son, who was 3 years old at the time, were going to stab him. Mr. Ray also accused me of having a camera in my microwave recording him and of being a part of a government conspiracy to get him.
Was there any other evidence of delusions?
Yes. Mr. Ray also accused his primary doctor of eavesdropping on his phone conversations and talking to his wife behind his back.
The third symptom you mentioned Mr. Ray suffers from are negative symptoms. What are negative symptoms?
Negative symptoms are symptoms that can impair a person's functioning. Examples include an impaired ability to manage emotions, such as angry outbursts or episodes of crying, withdrawing from relationships, and poor hygiene.
Was there any evidence Mr. Ray suffers from negative symptoms?
Yes. I witnessed it firsthand when Mr. Ray had a meltdown when I interviewed him in 2019. I also reviewed testimony from Mr. Ray's family doctor, Dr. Samantha DiGiuseppe, that supported my diagnosis.
What did you learn from your review of Dr. DiGiuseppe's testimony?
I learned that she saw Mr. Ray 3 times between 2010 and 2017. During these visits, Dr. DiGiuseppe reported that Mr. Ray broke down crying hysterically in her office and that he was disheveled and looked like he hadn't showered in weeks. When she asked Mr. Ray if he was okay, he told her he'd never been okay.
You said earlier that you interviewed the people closest to Mr. Ray. What did you learn from those interviews that support your diagnosis?
I spoke with Mr. Ray's former supervisor and learned that Mr. Ray tried to fight a coworker simply because they didn't follow his directions. I also spoke to Mr. Ray's wife, who reported that he would lock himself in the bathroom and cry for hours.
Objection.
What's your basis? On what grounds?
May we move outside the presence of the jury, Your Honor?
You may.
Hearsay, Your Honor.
Okay, counsel, do you have a response?
Yes, Your Honor. Under Federal Rule of Evidence 703, an expert is allowed to testify to inadmissible hearsay if the probative value substantially outweighs its prejudicial effect. These interviews are the basis for Dr. Riley's opinion.
Do you have a response to that?
Yes, Your Honor. I believe under Rule 703 that this is more prejudicial than probative. These, like she mentioned earlier, she's met with the defendant and has based her diagnosis on that. So these are not reliable facts or data that she is relying upon just from this hearsay.
How are they prejudicial?
The jury will rely on these, Your Honor, as true, and that she came to this diagnosis because of this hearsay.
Okay, I'm going to allow it. The jury will be given a limiting instruction on how to use this evidence. Go ahead.
Yes, Your Honor.
Continue, Dr. Riley.
Yes, so I also spoke with Mr. Ray's wife, who reported that he would lock himself in the bathroom and cry for hours. It was so bad that Mrs. Ray begged Mr. Ray to see a psychiatrist.
Did you learn anything else from your interviews that support your diagnosis?
Yes, Mr. Ray's father told me that Timothy Ray's mother was institutionalized for severe mental illness and that she abused Mr. Ray horribly.
Why was that important to you?
If someone has a family member who suffers from a mental illness like schizophrenia, that increases the likelihood that a child or sibling will also suffer from it.
You said that Mrs. Ray abused Mr. Ray. What did you mean?
Abe Ray reported to me that Mr. Ray's mother was neglectful and abusive towards him. She often refused to feed Mr. Ray and forced him to take cold baths. She then abandoned Mr. Ray at a very young age.
Dr. Riley, what evidence was there that Mr. Ray suffered from schizophrenia around the time of Nathan's death?
Mr. Ray exhibited signs of both visual and auditory hallucinations in front of both of the officers involved in his arrest. Mr. Ray told Detective Booth that he heard voices telling him to do what he did to Nathan. Additionally, Officer Wentz reported that at the traffic stop, Mr. Ray said that he could hear sirens of the CIA coming to get him.
Were those the only symptoms he showed that night?
No. Mr. Ray showed evidence of delusions. He accused both Officer Wentz and Detective Booth of being a part of the CIA and told Officer Wentz that the CIA had been watching him because they thought he was a terrorist. Mr. Ray's appearance and overwhelming body odor are also evidence of negative symptoms.
Dr. Riley, were you in the courtroom when Dr. LaGreca testified?
Yes, I was.
Did you hear Dr. LaGreca's opinion that Mr. Ray was faking his symptoms?
Yes, I did.
Do you agree with that opinion?
Absolutely not.
Why did you conclude Mr. Ray wasn't faking it?
Mr. Ray has been tormented by symptoms of schizophrenia since he was just 10 years old, well before the need for a legal defense.
Doctor, based on your review of the record, are you the only doctor to diagnose Mr. Ray with schizophrenia?
Well, I'm the only one who gave Mr. Ray the formal diagnosis. He has been treated for his symptoms consistent with schizophrenia.
What do you mean?
Last year, while Mr. Ray was in the Skelton County Department of Corrections, he made a mental health appointment. While the physician who saw Mr. Ray never formally diagnosed him, Mr. Ray was prescribed Seroquel.
Why is it significant that Mr. Ray was prescribed with Seroquel?
Seroquel is an antipsychotic drug. It's used to treat serious mental disorders such as schizophrenia, bipolar, and sudden episodes of mania or depression associated with bipolar disorder.
Your Honor, I have no further questions at this time.
Okay, cross-examination.
Yes, Your Honor. Dr. Riley, you said earlier that you are the only doctor that has ever diagnosed the defendant with schizophrenia.
Yes, I'm the only one who's made a formal diagnosis.
You made this formal diagnosis in September of 2019
That's correct.
while the defendant was in jail,
That's correct.
where he had been for nearly a year awaiting this trial for killing his son.
Yes, that's correct.
It was in this interview that the defendant claimed symptoms.
Yes.
He claimed that he was having hallucinations.
Yes.
He claimed that he was having delusions.
Yes.
And he claimed that he was hearing voices.
Yes.
Now, the defendant had never claimed any of these symptoms before.
No, he'd never claimed them, but he did exhibit them to Officer Cruz, to Dr. DiGiuseppe, and to Jessica Ray.
But he had never reported them, correct?
No, he only exhibited them.
Now, Dr. Riley, 2019 was not the first time that you evaluated the defendant, right?
No, I also evaluated him in 2010 as well.
Exactly. And in 2010, it was your professional medical opinion that the defendant was not schizophrenic.
Yes, that was my diagnosis at the time. I diagnosed him with generalized anxiety disorder at the time.
Because the defendant denied having hallucinations.
Yes, at the time he denied them.
He denied having delusions.
Yes, at the time in 2010 he denied them.
And he denied hearing voices in 2010.
That's correct.
So in 2010, you diagnosed him with general anxiety disorder.
Generalized anxiety disorder. Yes.
So it was not until the defendant paid you for your evaluation for this trial that you diagnosed him with schizophrenia.
That's not correct. I was not paid for my opinion. I was paid for the time and the work that I put into evaluating the defendant, but I was not paid to give this opinion.
But it was not until you evaluated him in jail that you diagnosed him with schizophrenia.
That's correct.
Now, Dr. Riley, you know that you are not the only doctor who has evaluated the defendant.
Yes, he was also evaluated when he was in Skelton County Corrections.
Right, but he was also evaluated before that by Dr. DiGiuseppe 3 different times.
Yes, and during those times, he actually exhibited those symptoms I mentioned earlier.
But Dr. DiGiuseppe never diagnosed the defendant with any mental illness.
No, she never made any formal diagnosis.
And then the defendant saw a different doctor, like you said, while he was in jail just a month after you diagnosed him with schizophrenia.
That's correct, and there he was prescribed an antipsychotic.
But at this evaluation with this different doctor, he denied having hallucinations.
It's not written whether or not he had hallucinations.
It is not written that he did not report having delusions.
It doesn't specifically say that he denied any of these things, but it doesn't say that he had them, so that's correct.
But it is not on the report that he did not anywhere on the report say that he was having hallucinations.
That's correct.
It is not on the report that he said that he was having delusions.
That's correct.
And it is not on the report that he said he was hearing voices.
No, it was not written on the report.
And you know that this other doctor in 2019 did not diagnose him with any mental illness.
No, but the doctor did treat him for what could be schizophrenia.
What could be, but you don't know for sure, right?
My conclusion based off of my evaluation is that he is schizophrenic.
Well, Dr. Riley, let's talk about your evaluation in 2019. In this evaluation, you said that for the most part, the defendant appeared fine.
Yes, for the most part.
You said that he spoke eloquently.
That's correct.
Appeared very coherent.
Yes.
But you also said that he was suffering from schizophrenia.
Yes, that's correct.
A disease that you said is linked to his mother's alleged mental illness.
Yes, that's correct.
But you have never evaluated the defendant's mother.
No, but I received reports of the symptoms and came to the conclusion that she was likely suffering from schizophrenia.
But you have never met the defendant's mother.
No.
You have never seen her medical records.
No, I have not.
You have no idea whether the defendant's mother was ever diagnosed with any mental illness,
No,
including schizophrenia.
that's correct.
Well, Dr. Riley, as an expert, you are familiar with malingering.
Yes,
That's essentially faking symptoms.
yes,
So you know that one of the signs of faking it is the inability to keep your story straight.
yes, that's correct.
And you know after reviewing the reports that the defendant repeatedly told Detective Booth that he killed Nathan in Nathan's bedroom.
Yes,
But the defendant told you that he killed Nathan in the kitchen.
yes,
Dr. Riley, you know another sign of faking it is acting out in police presence.
I'm sorry, you cut off earlier. Can you repeat that?
Of course. You know that another sign of malingering is acting out in police presence.
That's correct.
And you know that when Detective Booth questioned the defendant, he started to scream.
Yes,
You know that he cried uncontrollably.
yes, and this is actually something that he exhibited in front of Dr. DiGiuseppe as well in her 2014 evaluation. He was crying
All right.
hysterically at the time. Yes,
But you know that another sign of malingering is exhibiting symptoms that you have never reported before.
yes, that's correct.
And we have already established that 2019 was the first time that the defendant claimed many of these symptoms of schizophrenia.
Yes, this is the first time that he claimed them, but again, he had been exhibiting them since 2010.
But this was the first time that he reported them.
First time he reported them, that's correct.
Dr. Riley, you said that there was always the possibility of malingering.
Yes, it's something I consider.
You said that there is always the possibility that the defendant is faking it to create a legal defense.
Yes, there's always that possibility.
And you even said that the worse the crime, the higher the likelihood that a defendant is faking it to make a legal defense.
Absolutely. Malingering is something I always consider, but in this case, the evidence for schizophrenia far outweighed the suspicion for malingering.
But you said that the worse the crime, the higher the likelihood that a defendant is faking it, correct?
That's correct.
Nothing further.
Any redirect for this witness?
No, Your Honor. May this witness be excused?
Yes. Any further witnesses or evidence on behalf of the defense?
No, Your Honor. With that, the defense rests.
Okay, so would both sides like a brief 5-minute recess to prepare for closing arguments?
Yes, Your Honor, and a time check on the record.
Okay, that's fine. If the timekeepers can let us know where they're at.
One moment while we confer.
No problem. We'll put it on the record when we get back from our recess. See everyone in 5 minutes. Okay, is everyone back and ready to proceed?
Yes, Your Honor. The state's ready to proceed with closing statements.
Okay, is defense also ready?
Yes, Your Honor.
Okay, did we want to put that time check on the record?
Yes, Your Honor. Our timekeeper.
I have 12 minutes and 45 seconds remaining for the prosecution.
Okay, and for defense?
For defense, I have 12:36.
And do both sides agree?
Yes, Your Honor.
Okay,
Yes,
perfect.
Your Honor.
Okay, so we will now hear closing arguments from each party. Everyone should switch their view back to speaker view. Again, that's in the top right-hand corner so that we can focus on the person actually speaking. So we'll start with closing argument from the people.
Your Honor, if I may, before I begin, reserve the remaining of my time for rebuttal.
Yes.
Thank you, Your Honor. Today, the defense got up here and tried to put on a smoke and mirror show, making today's case about mental illness, making today's case about whether or not this defendant was suffering from schizophrenia when he strangled his 6-year-old son to death. But let's not forget that on October 17th, 2018, Jessica Ray lost her only baby at the hands of her very own husband. Let's not forget that on October 17th, 2018, this defendant wrapped his belt around his 6-year-old son's neck and watched as the life left his little body. Let's not forget that on October 17th, 2018, this defendant strangled his own son to death. Because of that, the state of West Carolina has charged this defendant with first-degree murder. And as the state, as the party bringing this charge, it was our burden to prove to you today beyond a reasonable doubt that this defendant is guilty. We gladly accept that burden, because what the overwhelming amount of evidence in today's case has shown is that not only did this defendant kill Nathan Ray, but did so knowingly, willfully, and intentionally. Members of the jury, how did we prove our case today? Today, Detective Booth took the stand and told you that after making sure that this defendant understood his rights and understood what he was doing at the police station, you know what he said? I understand. I want to tell you everything. Why would this defendant want to tell Detective Booth everything? Because he was so guilt-ridden by what he had just done to his only son that he knew he had to tell the truth. What was that truth? It was in that interview that the defendant confessed to murdering his own son. In that interview, the defendant admitted to wrapping his belt around Nathan's neck. The defendant admitted to pulling that belt so tight that Nathan stopped breathing. The defendant admitted to wrapping his dead son's body in a garbage bag and tossing him in the backseat of his car. The defendant admitted to driving his son's dead body to Brandywine State Park. The defendant admitted to digging his own son's shallow grave. Members of the jury, the defendant admitted to tossing his son's body in that grave, throwing just a little bit of dirt on top, and leaving his son to rot. Now, I want to address something that opposing counsel said in opening statements. They told you that the defendant, he was tormented by voices. But you know who was tormented? Nathan Ray. When his dad wrapped his belt around his little neck, Nathan Ray was tormented as his dad strangled him to death. Members of this jury, there is no question today as to who killed Nathan Ray. We know because of that confession that this defendant killed his son, which means the only thing we had to answer today was whether or not Nathan's death was premeditated. And as the judge just explained to you, premeditation can happen in seconds. There is no set amount of time for premeditation to occur. The decision to kill can be made in an instant. Y'all, today you learned that this defendant was so angry at his 6-year-old son that he walked out of Nathan's room, walked into his own bedroom. He tried to calm down, but did he stay there? No. This defendant grabbed his belt because he was calculated. When the defendant walked back into Nathan's room, he was in control. Members of the jury, there was only one thing on this defendant's mind when he wrapped his belt around Nathan's neck. In that moment, this defendant was committed to killing his son. Y'all, you do not wrap a belt around your child's neck unless you intend to kill them. That moment that this defendant confesses to is premeditation, which is why you must find this defendant guilty of first-degree murder, period. But instead, the defense got up here today and tried to tell you that the defendant, he did not know that what he did was wrong, that the defendant did not understand the nature and consequences of his actions. And in doing so, they asserted what is called an affirmative defense, which means the defense bore the burden of proving to you that not only did the defendant suffer from a severe mental illness, but as a result of this mental illness, he was unable to appreciate the nature and consequences of his actions. Members of the jury, the defense cannot meet that burden today. The defense cannot and have not proved to you today that this defendant did not know that what he did was wrong. Y'all saw his search history. Do people who do not understand that what they did was wrong Google how to get rid of a body? Do people who do not understand that what they did was wrong Google countries that don't extradite for murder? Absolutely not. But that is exactly what this defendant did. He got out his cell phone, opened up Google, and Googled, does bleach destroy a body? He Googled how to get rid of a body. He even Googled what countries don't extradite for murder. This defendant Googled exactly how to get away with killing his own son. Members of the jury, this defendant truly did not understand that what he did was wrong. Why did he try to hide it? If this defendant truly could not understand the nature and consequences of his actions, why did he drag his son's lifeless body through Brandywine State Park and leave him there as if he was trash? I'll tell you why. Because this defendant is committed to getting away with murder. So committed that today you met Dr. Riley. Now, when Dr. Riley took the stand, we all noticed that she was testifying to everything that this defendant paid her to say. Dr. Riley is the same doctor that diagnosed this defendant with general anxiety disorder in 2019. So, how did she reach her opinion today? Based on statements made by this defendant in 2019. You see, after sitting in jail for almost a year for murdering his son, he realized he'd already confessed. There was only one way out. So while sitting in that jail cell, he told his paid expert that he heard voices, that he suffers from hallucinations, that he has delusions. But members of the jury, that is the first time that this defendant has ever claimed any of those symptoms. But it isn't the first time that he's seen a doctor. It isn't even the first time that he's seen Dr. Riley. But after sitting in jail for almost a year for first-degree murder, this defendant finally claims to have those symptoms. He did not claim those symptoms in 2010, not in 2011, not in 2014, not in 2017. But while sitting in that jail cell, he finally does.
Does that make sense? Of course it does. Because this defendant has been calculating how to get away with killing his son since he wrapped his belt around 6-year-old Nathan's neck. Members of the jury, Dr. Riley also stood up here today and tried to tell you that this defendant inherited his schizophrenia. He inherited his severe mental illness from his mother. But y'all, Dr. Riley has never met the defendant's mother. Dr. Riley has never evaluated the defendant's mother. Dr. Riley has never even seen her medical records. How does she reach that conclusion? Based on a phone interview with the defendant's father, where the defendant's father claims that she had mood swings and was institutionalized. Y'all, we have seen no record of that, and neither has Dr. Riley. But y'all, that phone call was enough for this expert to take the stand today and tell you that he inherited a severe mental illness. Y'all, this defendant does not have schizophrenia. He just wants you to think he does. Members of the jury, this defendant, just like on October 17th, 2018, just like he is today, was calculated, was controlled, and today he sits before you committed to getting away with murder. The defendant is guilty of first-degree murder. Find him guilty.
Thank you. Is defense prepared for their closing argument?
Yes, Your Honor.
Okay, whenever you're ready, go ahead.
What happened to Nathan Ray was absolutely horrible. No one can deny that. The heart of any decent person breaks when you hear about a child dying so young, especially under circumstances like this. And as simple as it is to look at Timothy Ray and say, he did it, that's that. This case is much more complicated, and the job you have is much more difficult. That's because the evidence has shown you that Timothy Ray is a man troubled, tormented, and trapped in a mind overcome by mental disease. The judge has instructed you that if you find that there is clear and convincing evidence that Mr. Ray suffers from schizophrenia, and that as a result, he didn't understand the nature and quality of his actions or didn't understand his actions were wrong, then the law requires that you find him not guilty by reason of insanity. As my co-counsel promised you during his opening statement, the evidence has shown that Mr. Ray was a man troubled, tormented, and trapped in a mind overcome by mental disease by proving two things. First, that Mr. Ray suffered from schizophrenia on October 17, 2018. And second, that as a result, he couldn't understand the nature and wrongfulness of his actions. So let's take a look at that first point, that Mr. Ray suffered from schizophrenia on October 17, 2018. Mr. Ray's struggle with mental illness started from the moment he was brought into this world by an abusive, mentally ill mother. During his early childhood, she would refuse to feed him, leave him in cold baths, and even abandoned him and his father before she was committed to a mental hospital. As sad as the beginning of Mr. Ray's life was, I'm not telling you about it to get your sympathy. I'm talking about it because it helps explain how Mr. Ray's schizophrenia developed. Today, you met Dr. Shane Riley, a forensic psychiatrist with 20 years of experience. When Dr. Riley testified, she told us exactly how much trauma has a huge impact on a child's mental health and development. And there's no question, being abandoned and abused by your mother is traumatic to any child. Dr. Riley also told us that, like many other medical conditions, having a mentally ill parent makes it more likely that a child will develop mental health issues. By 10, Mr. Ray was having auditory hallucinations or hearing voices. By his early 20s, he started having visual hallucinations while in the Army. And Well, Mr. Ray denied having those hallucinations in 2010. We do know that he had to be hospitalized at that time for 3 days. And just 4 years later, he was experiencing mood swings so severe that his wife begged him to get help. Just like he did in the Army, Mr. Ray tried minimizing those symptoms at first. But his doctor, Dr. Samantha DiGiuseppe, said that when she tried talking to Mr. Ray about his marital issues, he started crying so uncontrollably, she struggled helping him to calm down. Just a few years later, things had gotten even worse. When Mr. Ray saw his doctor again, he was disheveled and looked like he hadn't showered in weeks. He even screamed at Dr. DiGiuseppe, accusing her of plotting with his wife against him and listening in on his phone calls. That decade of decline is what allowed Dr. Riley to diagnose Mr. Ray with schizophrenia. Dr. Riley didn't just pick this diagnosis out of thin air. She used this, the DSM-5, which both she and Dr. LaGreca agree is the standard for diagnosing mental disorders in this nation. And a person who has at least 2 of these symptoms meets the criteria for a diagnosis of schizophrenia. But Dr. Riley actually told us Mr. Ray has 3 of those symptoms. Remember how he thought that his doctor was plotting against him and tapping his phone? That Detective Booth and Officer Wentz were CIA agents after him for terrorism? Or how he insisted that there was a hidden camera in the microwave when Dr. Riley evaluated him in 2019. Those are all delusions, one of the symptoms of schizophrenia. And those auditory and visual hallucinations we talked about earlier are another. That right there supports a diagnosis that Dr. Riley gave Mr. Ray. But Dr. Riley also told us that Mr. Ray experiences negative symptoms like poor hygiene, sleepwalking, an inability to control his emotions, all dating back to at least 2010. Nathan's mother also told Dr. Riley that Mr. Ray was so disturbed, he would lock himself in the bathroom for hours and would refuse to come out. She's the last person that would make something up to help Mr. Ray. Dr. Riley and Dr. DiGiuseppe also described incidents of Mr. Ray's wild mood swings and angry outbursts. He even attacked a coworker. Members of the jury, unless Mr. Ray has spent the last 10 years intentionally trying to destroy his marriage, alienate his family, and ruin his life, there's no way he was making this up. But that's what the prosecution's witness, Dr. Mac LaGreca, told you. He says that Mr. Ray was faking it. But what evidence is there to prove that? The fact that Mr. Ray was facing criminal charges? If that were enough to show that Mr. Ray was malingering, like Dr. LaGreca called it, then the law wouldn't allow people to bring in evidence of their mental illness. Dr. LaGreca knows that. That's why he's tried to convince you that all of the symptoms Mr. Ray has been experiencing for years weren't really symptoms. Mr. Ray's belief that the CIA was after him, that his doctor was plotting against him, Dr. LaGreca says none of those are delusions. Really? If those aren't delusions, then what does the prosecution call them? And why would the prosecution want you to ignore the evidence showing that Mr. Ray was tormented and trapped by a troubled mind? Because it means that Mr. Ray couldn't understand the wrongfulness of his actions, which is my second point. From the moment Mr. Ray was pulled over at that DUI checkpoint by Officer Wentz, it was clear to her that something was off. Mr. Ray looked a mess and smelled even worse. When Officer Wentz asked Mr. Ray for his driver's license, she had to specifically remind him that it was sitting right next to him. He was also frantically ranting about the CIA being after him and started doing jumping jacks and refused to stop even after Officer Wentz pointed her gun at him. Based on Officer Wentz's academy training, she knew that something was off with Mr. Ray, and that's why she told Detective Booth. Then there's the shovel, the plastic trash bags, and the bleach bottles. The prosecution wants you to believe that this is evidence of Mr. Ray hiding what he had done. But if Mr. Ray were hiding the fact that he killed Nathan, wouldn't he have thrown them in a dumpster behind a store or at the park? Or put them in the trunk instead of leaving them in the place where anyone and everyone could see, then driving right up to a police checkpoint? If Mr. Ray were trying to hide his son's body, would he have left the body in the park, in the middle of Skelton, for everyone to see? Given all of the evidence showing that there was something wrong with Mr. Ray, Detective Booth should have done more to look into what caused Mr. Ray's actions. At a minimum, an investigator looking for a fair and just outcome would have interviewed Mrs. Ray about her husband's mental health history, or the family closest to Mr. Ray, like Dr. Riley did. So why didn't Detective Booth do that? Well, he's been a police officer for 23 years, so it's not an experience. He's assigned as a detective to the homicide unit, so we know he's competent. So what is it? Well, today we learned that Detective Booth has a personal connection to this case. Not only does Detective Booth have a son Nathan's age, the two kids actually played on the same soccer team together. Weeknight practices, games on the weekends, handing out snacks after the games. We all know how close you can get to the other families on the team. So imagine how hard it was for Detective Booth to find out that not only was he investigating the murder of a small child, it was a child he knew, killed by a parent he'd spent time with on the soccer field with. That's why Detective Booth couldn't look at this evidence objectively. He was too close to the people involved. That's why Detective Booth insisted that he knew there was nothing wrong with Mr. Ray, even though the evidence showed otherwise. That's why Detective Booth got on that stand and said that he only preserves relevant evidence. He didn't preserve that video. Detective Booth didn't preserve that video because he says it's not relevant. This evidence would have helped prove that Mr. Ray was mentally ill. And that's why Detective Booth ended the interview by saying, "You're a piece of shit, Tim. You'd be better off dead." Between those comments and Mr. Ray's behavior, there was no way Detective Booth was going to let that video see the light of the day. That's why Detective Booth let that video be destroyed. Now, members of the jury, in a moment, the prosecution is going to get to speak to you again. One last chance to answer all of the questions you have left by their failure to conduct a thorough and unbiased investigation. And when they do, I want you to listen closely. When they tell you why you should rely on Dr. LaGreca, even though his opinion ignores important facts. And when they tell you that Detective Booth was the right person to investigate this case, you'll know that the only just verdict is a verdict finding Timothy Ray not guilty by reason of insanity.
Okay, prosecution, would you like to make a rebuttal argument?
Yes, Your Honor.
Okay, whenever you're ready.
Ladies and gentlemen, the defense just got up here and published to you the DSM-5, laying out to you all of the symptoms necessary to diagnose someone with schizophrenia. And as they put those check marks next to all of those symptoms, you need to remember, this defendant did not report those symptoms until he was sitting in jail, for murdering his baby. Y'all, you heard from Dr. LaGreca today. He told you that schizophrenia is rare. Less than 1% talk about that, have suffered from schizophrenia. Y'all, you know what isn't rare? Malingering. Members of the jury, malingering. 19% of people facing criminal charges, they fake their symptoms, which is exactly what this defendant is doing today. But y'all, he has the audacity to stand up here and try to make you think that he's the victim. But y'all, the only victim in today's case is Nathan Ray, who died at the hands of his very own father. Members of the jury, this defendant is guilty of first-degree murder. Find him guilty.
Okay, so at this time, judges should complete their ballots. I'm going to ask everyone to stay on until all the ballots have been submitted, and then we'll do some brief comments, okay? Sounds good. So whenever the jurors have submitted their ballots, activate your video and audio so I'll know that you're finished. We're just waiting on one more juror and then we'll be good to do comments. Did Mr. Kaplan submit? Oh, there he is. Okay, have all ballots been submitted?
Yes.
Yes.
Okay, perfect. So I'm going to give everyone just a brief opportunity to make one or two comments to either teams as a whole, everyone as a whole, or individual advocates. I'm told to let you guys know not to spend too much time because we want to let them prepare for their round this afternoon. So whoever wants to start, feel free to give some comments.
Sure. Would anybody mind if I go first? I have to get going in a few minutes. So is that all right?
Yes, that's fine. No worries. Go ahead.
Great. Okay. My name is Jenna Mathias. I'm a graduate of the Klein School of Law. I am currently a litigator at Lafayette, UC, and Kent LLP in the city. I work in plaintiff's injury, personal injury plaintiff's work. I work in construction, premises, and products liability. I am a trial attorney. And I'm also a professor of trial advocacy. So I live and breathe trial ad, and I love it, which is why I'm here doing these competitions. This is perhaps one of the most impressive groups of trial performances that I have ever seen, including in my time as a trial ad student, my time as a trial ad professor, and my time judging these competitions, which I've now been doing for several years. My criticisms are so ridiculously nitpicky because I think that you guys did a fantastic job. You were amazingly paced. You all had fantastic tone. You all used amazing advocacy skills with regard to tone variation, volume variation, to emphasize points. You were all incredibly passionate and all knowledgeable about what can be sometimes difficult material to grasp. So I have to give you guys so much credit for the work you've done here. If I can just say maybe two things of criticism overall. I know that we're on computers and I know that the Zoom format is kind of odd. I think you guys all really made it, held yourself up to that challenge and did a great job. Just be aware of your movements and your hands. If you can see them in the video, if you have a tendency to play with your hands at all out of nervousness, which I do and I'm doing right now, either try to keep them out of the frame or have them down by your side. I know that the power stance is something that people always talk about, having them in front of your belly and having them here and keeping them here, and you can't see them while I'm doing it, but I'm down here. If you have a tendency to play with your hands, I would just put them down by your side. And one other thing, I would say that your passion absolutely came through each and every one of you and in a very impressive way. But be careful of passion becoming anger and kind of going at the jury in a way. And you almost mean you're yelling at the jury. Because I know you're yelling at the defendant because he killed his son and that's awful. But also it can come off a bit whoa, okay, now I feel like I'm being yelled at. Otherwise, everything I have is just so ridiculously nitpicky. It's not even worth saying. You guys all did amazing. So congratulations on a great job. And I know you all go far in your career.
Thank you.
Thank you.
Okay, so who would like to go next?
Good. I want to commend everyone on what a fantastic job you did. I was nervous for everyone with this Zoom format. I really thought to myself, it's got to be really hair-raising. I thought the use of that exhibit with the timeline was superb. And it was superb that it worked and that it came off. I thought that was really good. And I thought the examination by both sides of the psychiatrist was wonderful. She was a great witness. I've put on, examined and cross-examined many psychiatrists. They, to me, are the most squirrely witnesses in the world. And my daughter is a shrink. But I find that when I have to deal with a psychologist or a psychiatrist, they're all over the place. She was a great witness. Both sides did a really outstanding job with her. Criticisms that I have are likewise very minor and nobody really wants to hear them. The only thing that I would say is think a little bit about varying your tone. If you get very intense, if you get very angry, there are times when that's appropriate, and then there's maybe a time to back off that a little bit. But I thought everybody did a wonderful job. I've sat as a judge in these things for many years, and I really thought with all the challenges of technology and everything else, I could not imagine how you were going to pull it off. So congratulations to everyone.
Okay, I guess I am last. I have been a trial attorney for a long time. I taught trial ad for 28 years at another law school. I have been a plaintiff's attorney for a long time. You guys did a fabulous job. It was very, very well done. Everybody did a good job. And while we're required to go ahead and make findings here on various things, this is a very close case. I wouldn't have thought it when I took a look at the materials. You guys did a very good job of examination, of taking apart some of the experts in this case, because they were vulnerable. I will echo what the two other jurors said. Sometimes you got to notch it back a little bit. You get too involved in the case. While you certainly feel passionate about your side and your position, it's a question of, does that go ahead and advance your case? Here we know the issue is not whether he killed his son. He did a horrible thing. The question is, did he establish that? And you got to remember the burden of proof. Did he establish that he was not competent at the time of the commission of the crime? And you may want to take it back a little bit, because it's a difficult proposition. It was close in terms of the experts, and you guys really did a good job, I think, on the experts. So if you just turn it back a little bit and remember where you're trying to go, I think you'll be more effective on that. Good luck to you all, and I'm sure you'll do very well.
Thank you. So I'm not going to give many comments. My name's Heather Phillips. I'm a deputy district attorney, so I'm a prosecutor. I do jury trials, and so just to let you guys know, you did a great job. You all are better than some of the people that I see in actual court, so that's awesome. I loved the energy, loved the passion. Miss Mesmore, I thought you were awesome. I thought you did a fabulous job. Everyone did a fabulous job. I just love the fire and the energy. I think as a prosecutor, if you have a defendant who you think is making up a condition to escape killing his kid, I think that energy is awesome. So I thought you were great. You all did a great job. And yeah, thanks so much. I think everyone can log off now, and good luck to all of you in your next round this afternoon.
Thank you so much.
Thank you.
Congratulations and good luck.
Thank you.
Thank you.